Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and this is a pretty interesting case that was filed just yesterday, September 8th. This is the CFPB, although they call themselves now the Bureau of Consumer Financial Protection, but it's what everybody else in the world calls the CFPB, so the Consumer Financial Protection Bureau. But they have sued the biggest debt buyer in the nation. And that is a group of companies known as Encore, Midland Funding, Midland Credit Management, Asset Acceptance. And this relates to violations of the Fdcpa, the Fair Debt Collection Practices Act, and a 2015 consent order that these companies entered into with the CFPB for violating various laws. And so now they're back at it again, violating the laws. And so this is pretty unusual. We have a Republican administration with the CFPB that has definitely been scaled back. But what Midland is doing is so bad that even this CFPB has decided to file suit. So let's take a look at this. We'll drop down to paragraph 1, the introduction. So they say this is the second time we've had to do this because various laws are violated. So you'll see this initials or acronym CFPA, and that is the Consumer Financial Protection Act of 2010. Okay. Now, that's not something that we directly sue under. We sue under the Fdcpa, so the Fair Debt Collection Practices Act. And the Bureau's pointing out, hey, look, guys, we've already brought suit against you and you agreed to a consent order. You promised to do things, but you've been violating that consent order and you've been violating federal law. So let's identify the parties. We have Encore Capital Group, Inc. Think of that as sort of the parent company, okay? And that's in San Diego. And then you have this Midland Funding, LLC, which that's owned by Encore. It's in San Diego. Then you have Midland Credit Management, and it's also owned by Encore, and it's in San Diego. And Midland Funding and Midland Credit Management, they really operate hand in hand. We have filed dozens and dozens of lawsuits against these two companies. We almost always sue them together because they're really operated as one and the same. Now we have this other company called Asset Acceptance. This used to be a competitor, but it was bought by Encore. And while I don't personally see Asset Acceptance filing lawsuits nowadays, it still exists. Okay, so all these companies together form the largest debt buyer and collector in the U.S., revenue of over $1 billion a year, just a staggering number. And the whole purpose of these companies, their whole purpose is to buy defaulted debt and then collect from consumers. And so because of that, and the Bureau points out, if you look at their financial documents filed with the SEC, Securities Exchange Commission, they point this out. And so that's their principal purpose, which we need that to be able to show that each defendant is a debt collector under the Fdcpa. And so they're collecting debt related to consumer type debt, and the defendant, each defendant is considered a, quote, covered person under the CFPA. Okay, so let's look at the facts here. And this is going to get very interesting and very helpful if you're dealing with Midland. Either they're suing you, they're writing you letters, things of that nature. So 2015, there's a consent order, which again, that's where all these companies promise to do certain things. Now, they do not admit that they did anything wrong, but they paid a bunch of money and they made promises. So some of the claims were that they're making false representations. They're saying, hey, we're going to actually prove our case when they were not going to do that, filing false affidavits, saying we can enforce this claim against you when it's outside statute of limitation, telling consumers you have the burden of proof in litigation, which is not true. The debt buyer who sues you has the burden of proof, and making excessive inconvenient phone calls and not investigating consumer reporting disputes. Okay, so they paid at least $34 million to consumers, $10 million civil penalty to the Bureau. And then we have some of the requirements now that these defendants agreed to. So they can't sue you without having original account level documentation. And that term is defined in the 2015 order. And I'll put a link to that order so you can read it yourself. But after that went into effect, they filed hundreds of lawsuits without the original account level documentation. And then what about disclosures? So they have to have certain disclosures particularly when they're using either their own legal department or a third-party law firm. So they have to provide the consumer with a statement that, and when it says Encore, we're talking about Midland Funding, Midland Credit Management, Asset Acceptance, that either Midland or its agent, which could be the collection law firm, will provide the consumer with copies of certain original account level documentation at no cost. But the Bureau has found that at least 750,000 times they did that. They made collection efforts without putting in that required disclosure. Even though they promised the government in 2015 they would do it, there's at least 750,000 times where they did not do it. And more than 750,000 times that they did not say, hey, we'll provide this to you at no cost. And then there's 25,000 times they didn't say, we'll do this within 30 days. And they've, just on these accounts, not all the accounts, but just on these accounts, they've collected more than $300 million without providing those proper disclosures. So the consent decree requires that they provide this information upon request. But a couple hundred times, they told the consumers they would do it, but they did not provide that original account level documentation. And they've even filed lawsuits when they've not provided that documentation. And so the Bureau made Midland or Encore create a list of these consumers, and that's been provided. And so what's the big deal? Okay, so they don't give you the original account level documentation. What's the big deal? Well, it affects the consumer's ability to determine whether the debts are truly owed. It also affects decision making about whether and how to respond to the debts. Okay, now what about suing on time-barred debt? So a time-barred debt is a debt that's beyond the statute of limitation. Statute of limitation is a time period to sue in your state. Well, what about if they've waited too long? What can they do with time-barred debts? Well, the order back in 2015 says that you cannot collect on this without certain disclosures. Okay? So they have filed lawsuits, which they were not supposed to do, suing after the statute of limitations. And then what about just collecting on the debt? So not talking about suing, but sending letters, for example, on the debt. Well, they had to include one of two statements. So either the law limits how long you can be sued on debt, how long a debt can appear in credit report due to the age of this debt. We will not sue you for it or report payment or non-payment to a credit bureau. Or the law limits how long you can be sued on debt because of the age of your debt. Will not sue for. Here's the reason to have those two different things. The time period to sue is not necessarily the same time period to credit report. So your state might say they have to sue within 3 years, but they can credit report, which is really national for all states. They can credit report for 7 or 7.5 years from the date that you defaulted. So that's why there's kind of a discrepancy. Now, if it was, let's say your statute of limitation is 3 years and this is 8 years later, well, they can't sue or credit report. So that's what they need to say. Or they can just say, we can't sue you for it. But look, they sent out 425,000 letters to collect time-barred debt without the disclosure. And then this is really an odd one, okay? And I think this really upset the Bureau. Obviously, all this stuff upset the Bureau, but look at this starting in paragraph 38. So 2016, Encore, which again means Midland Funding, Midland Credit, Asset Acceptance, start using a payment processor based in a foreign country. And so sometimes when you would pay, you're getting hit with international transaction fees. But they didn't disclose that that fee was possible. And so there's all these fees that people are paying. And look at paragraph 42. Consumers have no control over how Encore processes payments, had no reason to believe their payments to Encore, a domestic company, could result in international transaction fees. I mean, can you imagine that? What if your dentist down the road says, hey, do you want to pay your $1,000 bill with a credit card? You say, sure. And then you get hit with these international transaction fees. Like, why would I pay international transaction fees for my dentist down the road or for a company based in San Diego, California? Makes no sense. And so those are the facts. Now, what does that mean? In other words, why is the Bureau suing these companies? Well, in lawsuits, we have count 1, count 2, count 3. These are just your reasons you're suing. And so they say, look, you violated the CFPA by violating the order. Okay? So you're not supposed to do anything that would violate the order. And so how did they violate the order? Well, look at paragraph 48. They sued the consumers without that original account level documentation, legal collections without the disclosures required, didn't provide the original account level documentation within 30 days of the consumer request, sued on time-barred debts beyond the statute of limitation, and collected or attempted to collect on time-barred debts without providing the disclosure required. And so that would violate the CFPA. Now, we have count 2, which is deceptive acts and practices. So again, we're staying in that same law, the CFPA, and it's basically saying don't do things that mislead people, that deceive people. And if you do that, you have violated this law. And so we have the representations that would provide the original account level documentation were deceptive. They would say, hey, we're going to provide it, but then we wouldn't provide it. And that's going to mislead people. And then suing on time-barred debts. Okay, so they sued more than 100. I can tell you, it's way more than that, but the Bureau is just saying, hey, we can clearly document more than 100. And actually, this is Midland admitting there were at least 100 people. And so when you file a lawsuit, it implicitly or explicitly, directly or by implication, says that the consumers had a legally enforceable obligation to pay this debt to Midland. But that's untrue because statute of limitation. And so they say these were material, which material just means that it's important, it makes a difference, because they're likely to affect the choices about how to respond. And so you might have a consumer with limited resources. They're more likely to pay a legally enforceable debt than one that's not, because if you don't pay a legally enforceable debt, you could be sued and have a judgment and garnishment. But if it's time barred and it can't be enforced against you, or I should say should not be enforced against you, then you sort of leave that one alone. And look, this is just common sense. If I've got a debt that I owe to Capital One and it's a year old, and I've got a debt that I owe to Midland that's 10 years old, and I don't have enough money to pay both of them, well, obviously I'm going to pay the Capital One because they can sue me, they can credit report. I'm not going to pay the Midland who can't do anything to me, and it's too late for them to legally sue me. All right, now we get to the Fdcpa, which this is the law that we can actually use as consumers. So this is count 3. So they say, look, Section 807, which is the same thing as 15 U.S.C. Section 1692E. This is the more commonly used numbering system in the court cases. So 1692E says don't do anything that's deceptive or misleading. And then it gives us a bunch of examples. Okay, so we have subsection 2, 5, and 10. So this is no false representation as to the legal status. Okay, and then section 5 is threats to take action that cannot be taken or that you could take but you don't intend to take. So if a company says, we're going to sue you, and they never intend to sue you, well, that would violate the law. Or if they say, we have the legal right to sue you, and they really don't, that would be a lie. And then subsection 10 is just kind of a general false representations or deceptive means to collect or attempt to collect any debt. Okay, so how do their facts fit with this law? The representations that would provide original account level documentation were false. Okay. And these could be made in letters or phone calls. The lawsuits on time-barred debts, those were false. Those were misleading. Okay. And then we have, this is interesting because this is useful when you've been sued and you win and then maybe you sue Midland. The reasonable interpretation of these lawsuits implicitly or explicitly, directly or by implication, was that consumers had legally enforceable obligation. These were false because the debts had passed the applicable statute of limitations, so there was not legally enforceable. Now I'll say this, not everybody agree with what the Bureau is saying there. In most states, the affirmative defense of statute of limitation, you have to plead that. So the debt may still be owed, but it's that Midland has no right to collect it. What I think the Bureau is saying, and maybe should say a little bit differently, is there's actually another section of the law, and that is 1692F, that says don't do anything that's unfair. And most courts have said when they sue after the statute of limitations has expired, that is an unfair act. Okay, so usually we want to bring these together. We say it's deceptive and it's unfair. Now, for whatever reason, they've sort of traveled down the path of just being deceptive here. Okay, then we go to this next count. Violated the CFPA by violating the Fdcpa. Okay. And then we have count 5, unfair acts and practices. And it's just saying everything that's been described, that's unfair. Okay. And then what is the CFPB, the Bureau, wanting here? They want an injunction that says to the defendant, stop violating the law. Okay. They want other relief, injunctive relief that's just and proper. In other words, they're kind of leaving their options open here. They want damages against the defendants. They want the defendants to have to pay money to consumers. And they want, this is an interesting idea, it's called disgorgement. And that's the idea that you illegally obtain, let's say, $50 million, $100 million. Those are ill-gotten gains. You did not deserve that money. We want you to have to pay that money back. So we're saying you did a bunch of bad stuff. Now give us all the money you made from that. And then they want penalties on the defendants, and they want the defendants to have to pay the Bureau's cost in this, and then whatever else they're entitled to. And so we see this is the principal deputy enforcement director. We've got deputy enforcement director, assistant litigation director, and then they have an attorney that's licensed in California because this was brought in California. So what's the take-home message from all this? Well, I'd suggest to you a couple things. Number one, there is an idea among some judges that, hey, I mean, these companies agreed to this consent order. They wouldn't turn around and violate it again. How stupid would that be? Pretty stupid. And these companies, they're not stupid in the sense that they're not smart, but they act in very foolish ways and in very, maybe I should say arrogant rather than stupid. They act very arrogantly where, it'd be like you get caught robbing a bank, and so you give the money back and you agree to never rob a bank again. You're on probation. Guess what you do the next week? You go rob another bank, okay? Is that stupid or arrogant? Well, maybe it's both, okay? But there's kind of this idea, and the lawyers that defend these companies will say, come on, Judge, do you really think we would turn around and violate the law again? Yes, 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 okay? And that's what we've been saying when we sue these companies. And now we have the CFPB suing them saying exactly the same thing. Now, if you've been dealing with Midland, so again, that means Midland Funding, Midland Credit Management, Asset Acceptance, they're on your credit reports. If you're getting collection letters from them, if they're suing you, you need to look at those and say, okay, have they violated that consent order? Now, every state's a little bit different, and how easy is it to use the violation of a consent order in a private lawsuit, okay, that you file? Not that the Bureau files, but that you file. And so you have to do some research on that. But it certainly gives you a good argument. If, for example, they have promised to do certain things in the consent decree, and you see examples of that here, but then they violate it. Is that being deceptive? Well, it certainly is deceptive if, for example, Midland Funding says, hey, we're going to provide you with the documentation, and they have no intention of doing it, and you request it, and they don't do it. That certainly is deceptive, sort of beyond the consent decree, okay? But we look at all of this put together, and look, this is very, very bad for Midland, okay? And think about it this way. We're in the Trump administration, Republican, and while it's a stereotype, there's some truth to it that the Democratic administrations tend to be more favorable to consumers and Republican tends to be less favorable. Not always true. And there's certainly different contexts where the Republicans are going to be better for consumers than the Democrats. But as soon as Trump came in, the new director that was at the CFPB basically was like, how can I gut this thing? Okay. And that's not true of the current director. But I want you to think about how bad, how really, really bad are these companies acting, okay, for the current administration to bring this lawsuit against the very largest debt buyer and debt collector in the United States of America. Really, really bad for them to get to this point where our current administration is suing them. Okay, so that's how bad these companies are acting. And so it should not surprise you if you're dealing with Midland. And I don't know many people that still deal with asset acceptance, but maybe in other parts of the country they're more active. But certainly what I see my clients deal with is Midland Funding, Midland Credit Management. When you're dealing with these companies, you've got to assume that they are breaking the law. Okay. Now they would go, well, that's so unfair to assume that. Well, it's whether it's fair or not, it's accurate and it's legitimate to do that and say, okay, I'm going to look at everything. I'm going to read their letters. I'm going to check everything on the credit reports. When they sue me, I'm going to look at every single detail of it because it is very possible that they are violating the law. Okay, and we've been dealing with Midland Funding, Midland Credit Management for, I can't even tell you how long, defending lawsuits and suing these companies, and same thing with Asset Acceptance, although again, I don't see them much anymore. But if you get anything from these companies, I would be very, very suspicious of it. You want to check it out. Get with a lawyer in your state that does this type of work to say, hey, what are my rights? What are my options here? Now, this is really true of any debt collector, any debt buyer. But we have just an amazing example here of how bad these companies are acting, that this CFPB, okay, this is not the one that was filing all these lawsuits. Like, for example, in 2015, they got the first consent decree. That was under a different director, totally different philosophy. Now we have one that is, I won't say it's leaning toward the businesses, okay? I think the prior director was, but the current director, I think, is trying to be pretty even-handed here. But we see this is how bad Midland's acting. And really, all these debt buyers, I think, act in a similar way. So you need to really, really protect yourself. Be careful. Check everything out. And so, hey, guys, I appreciate you watching this video. I will put this link in the description or in the comments, and I'll also find the 2015 one because you can read in there what is original account level documentation. I think it's at paragraph 12 where it's defined. And then it goes on to describe what exactly these Midland companies have to do with it. But it's a great complaint here to read. And you can believe that Midland, well, I'll say this. It has two options. It can either say, okay, let's work out a deal, or it can fight back very, very hard. I suspect it's going to fight back very, very hard because this will be a tremendous cost to them. And it hurts their efforts in lawsuits around the country because now consumers can come in and go, you know, here's how crooked these guys are. The CFPB had to go after them again after they violated the 2015 consent order. Well, even if in your state that may not be admissible evidence, the judges will start to pick up on this and go, yeah, maybe I need to give a second look at these guys and be a little more careful before I just start ruling against consumers. So I hope that's helpful to you, and feel free to share this or subscribe to our channel, and I'll catch you guys in the next video. Okay, have a good one. Bye-bye.